Well, hello everyone. Thank you for joining us this lunchtime. We are just going to wait a couple of minutes to make sure we get the numbers in. Obviously, people get a little bit delayed in hanging out from one Zoom meeting to the next. So if you'll be patient, thank you, and we'll get underway in just a couple of minutes. What I think I'll do, I'll watch my counter, and when it gets to 12:35, I think we'll begin. We are taping this presentation, so it will be available if you have to miss some of it, or you'd like to watch it again, or if you know other people that may be interested. So I am aware of people's time, so we don't want to delay this too much. So we'll just give it another minute, and we can get started. All right, we might to get underway. Well, welcome everybody. My name is Richard Jagger, and before we start, I'd like to begin by respectfully acknowledging the traditional custodians of the land we are, well, virtually meeting on today, and they are the Bunurong Boon Wurrung and the Wurundjeri Woi Wurrung peoples of the Eastern Kulin Nation, and I pay respect to their elders past, present and emerging. As I mentioned, my name is Richard Jagger, and I'm a director of the Victorian Clean Tech Cluster. I'm excited that you've joined us today because we're discussing a really important area for every development company, and that is your IP and how to develop a strategy to protect it. Before I introduce our speakers, I would like to mention a little bit about the Victorian Clean Tech Cluster, as we have people today who are with us who are not members. Well, not yet anyway. Let's hope they might see the value in joining. So the VCC is a member-driven voice for clean tech in Victoria, with an aim to support companies, institutions and indeed the government as well, to help drive sustainable growth in a number of sectors that involve clean technology. We aim to provide a platform for members to come together, to share expertise and receive advice to drive the uptake of clean technology and economic growth, ultimately helping us achieve a more sustainable and circular economy. If you aren't yet a member, I would encourage you to visit our website, maybe connect with some of our members and look at how you could contribute and benefit from being part of the group. So today we will hear from two very experienced and talented people, Kathryn Morris and Janelle Borham, who are both principals in the Chem Life group at Griffith Hack. Kathryn is a chemist whose expertise lies in natural products, ag products, battery technology, water treatment and pharmaceuticals. Janelle is also a chemist and her expertise covers general chemistry, energy, polymers and food technologies. Janelle is also the Vice President of the Institute of Patent and Trademark Attorneys of Australia. So there's a lot of synergy between our two speakers and the markets covered by the members of the VCC. So I think we will gain a lot by the insight our two speakers have today. It is my understanding that together they have over 50 years experience in managing IP and supporting companies in managing their IP strategies. I will make the assumption that they started their journeys in this field when they were both teenagers. So anyway, today they will discuss the various types of IP and how they might be managed to derive the greatest benefit to your company or your organisation. So without further ado, I will hand over the floor to Kathryn.
Thank you, Richard, and thanks for the lovely introduction. Just as a matter of housekeeping before we start, that if you have any questions, we'd ask that you please put them in the question and answer section of the event screen, and our moderator Gemma will collate them, and we can discuss them at the end of the talk. Also, please keep in mind that there are If there are things that you're particularly interested in and would like to be expanded on in more detail, please let us know those topics, because we are planning a second talk later in the year where we will present a case study showing how a company may use IP in its business strategy over a period of time. So right, let's get to today's agenda. We're going to be talking about intellectual property, or IP as it's shortened to, and what it is, I guess, and generally how it's used in business. And we're going to talk about some of the particular rights, such as patents and trademarks and copyright, trade secrets and those sorts of things, as well as some issues around freedom to operate and capturing your IP. Next slide, please, Gemma. Okay, so what is IP? IP is it's really a broad umbrella term that encompasses tangible and intangible products of intellectual or creative effort. And intellectual property rights are the legal means by which such intellectual property is protected. Next slide, please, Gemma. And there are different types of IP and different categories, I guess, and some are registrable rights and some are non-registrable rights. So some of the registrable rights are patents, designs, trademarks, and plant breeders' rights, and these rights must be applied for. They must meet certain criteria, and they are usually managed by a patent office or trademark office, such as IP Australia. Oh, sorry, go back, please, Gemma. The non-registrable rights include things like copyright, confidential information, circuit layouts, and passing off. These rights are automatically accrue to a person that owns them, but they still need to be managed. So both kinds of rights need to be managed appropriately. When you have a registered right, timing might be crucial, and an applicant needs to be proactive in registering their rights. So, okay, next slide, please, Gemma, and over to you, Janelle.
Great, thanks very much, Kathryn. We're off mute now, so it's nice to be speaking to you all. So I'll touch first on one form of registered rights, which is trademarks. So trademarks are fairly familiar to a lot of people, and there are a number here shown on the screen. So they act as a badge or a symbol that distinguishes your goods or services from those of others, so that you can demonstrate your connection to those goods or services. About 95% of trademarks that are registered are things like words or logos, or a combination of the name with the logo, and some of those are shown here. It's also possible to get protection for what we call non-traditional types of trademarks, which might be something like the shape of a product. So the Toblerone bar might be an example of that. So any chocolate bar that is shaped in that triangular form, you would immediately associate with Toblerone. And also scent, sound and colour marks are also registrable forms of trademarks. So brands have a great deal of value, and particularly for businesses that have been established for a long time, the trademark rights and the brand value can amount to very large sums. Whilst that is the case, in fact, and often it's thought that intellectual property protection can be something that's quite expensive to obtain. In fact, at the outset, for trademark filing and registration, the costs aren't too great. Applying for a trademark and going through the process to have it registered, it would cost in the order of a few $100s, maybe $1,000 to $2,000. But for these companies, where the costs tend to increase relates to enforcing your rights and maintaining your rights. So it's often not enough to just have a registered trademark in existence. You need to be active in bringing your trademark rights to the attention of people coming into the space and stopping others from trying to get their trademarks registered that are similar. And referring to the McDonald's symbol there, it calls to mind the Big Mac trademark and Hungry Jack's recent introduction of a burger known as the Big Jack. So having the trademark is the step one, and enforcing or acting on your rights is step two. Trademark rights are also in a form an indefinite monopoly. So you apply for protection and you can re-register and renew your protection over time. Trademarks also have to be used or else they can be lost. So someone filing many trademark applications but not actually planning on using them or not ending up using all of them over time, those rights are vulnerable to removal. So next slide, please, Gemma. When it comes to choosing trademarks, it's important to ensure that your trademark is not descriptive. So if you have if you're involved in building wall panels, then choosing a trademark such as strong wall would be seen as descriptive. And one of the first steps that you want to do in relation to trademark protection is, firstly, there's a need to do a search. So if you engage a trademark attorney to apply for your trademark protection, these steps will be performed by them. But there are some things you can do yourself if you're just exploring the area. One first step is to conduct a search, and there's a link there for the Australian Trademarks Office database to type in, say, a word or a name that you're interested in and seeing what comes up. It's also important to search on the internet, because it's not just existing registered trademarks that might become a problem for you or might prevent you from getting your trademark registered, but also other people's use of names that are similar. Also, there's a requirement to identify what goods or services you wish to protect, and trademark protection is classified into a number of trademark classes. A few things you need to think about too is when to file and where to file. So it might be that if you're at the start of a business and you're developing new technologies, your trademark might not arise or might not be relied upon by you to distinguish yourselves or your products from others until later on in your journey. So it's not necessarily essential to register or apply for trademark protection very early on, but you'd want to get in and do it before you start developing a reputation and engaging with customers and consumers. It's also an important consideration is that when you apply for trademark protection in Australia, it's becoming quite common for Chinese companies to watch around the world for new trademark applications and immediately file trademark applications themselves in China as a means to try and get in ahead of you in China, and then to cause you difficulties and to demand a payment for transferring over that trademark to you. Domain names are also associated with trademarks, so filing for trademark protection and domain name registration on the same day is becoming quite conventional for larger companies. Once your trademark is registered, you can use that R symbol that you see there. Before registration, people may use the TM symbol. TM simply means that you think that the word or logo is acting as a trademark, but it doesn't give you any particular rights of itself. And in Australia, trademarks, an initial trademark lasts for 10 years and is extended in 10-year lots. If you're engaging with a designer to come up with a logo for you, just a tip is to make sure that you have the copyright assigned in that logo. And perhaps we'll move to the next slide and I'll talk a little more about copyright protection. No, first I'll talk about designs. So design registration is another form of registrable rights, and it relates to the appearance of a product, and it could be two-dimensional, such as a pattern applied to sheets of fabric for curtaining, or it could be 3D, such as the examples shown below. Now, overall, designs to be registered, they must be new and distinctive. So for designs, it's important to apply for your design registration before you do public application of your design and sales of your products created in the shape of your design. In contrast, trademarks, it's possible to start using your trademark and apply for the registration later. In Australia, it's a 10-year monopoly period maximum that's available. In other countries, the time periods are different, and that just also makes the point that IP protection is often country by country based. So if you wish to have protection in countries other than Australia, you need to go through a process to register your rights in multiple countries. And next slide, please. On this slide, there are a few points about the process. So there's an application that's filed and registered quickly. Designs, therefore, are fairly low cost as well. You apply for the design registration and submit the drawings, and next thing you know, you have a registered design. Before you can enforce it, it needs to go through an examination, but it's not an extensive process. Overall, I would say that designs are very effective for products that have a distinctive shape and help you best for addressing copycats, but design registration protection is fairly narrow in scope. So it is possible for a competitor to have quite a similar design, but with a few differences, and that is often sufficient to ensure that they don't infringe a registered design. So I like to think of them as being great for stopping copycats, low cost, get it in for a product that has a particular distinctive design, and leave it there. So next slide. Copyright now is one of those forms of unregistered rights. A copyright is a right to exclude others from copying. So the real key here is the copying aspect. A copyright is automatic, and so it comes into existence on creation. But if you want to enforce your copyright in a particular artistic work, you want to make sure you've got very good documentation that you are the originator of it and that you have things like version control, or you keep good records of it, of your copyright, so that if in future you need to enforce it, you can show that you own the copyright and another party has copied it. Now, one thing I'll mention here is that it's across the world, people have gotten this idea that to avoid copyright, you need to make a change by at least 10%. Now, that is not at all a concept that finds foundation in copyright law. Copyright protects the owner of the copyright from substantial copying of a substantial part of someone's artistic work, and 10% is not really a guide as to what is a substantial part. In Australia, it lasts for 70 years from the author's death, but the time periods are different in different countries. A little note here, that's the third point in the key takeaways, is that in some countries, copyright is in fact a right that is registered. So the USA and China are countries where you register rights, but there are conventions and treaties between different countries such that, for instance, if you have copyright created in Australia, you can enforce that copyright in the USA and vice versa. Next slide, please. And over to Kathryn.
Thanks, Janelle. Okay, well, I'm going to tell you a little bit about patents, which is an area where Janelle and I both work a predominant amount of our time. A patent is a right that protects how something works, the function of a product or a process. So it can cover, we've got mechanical objects there, but they can be any kinds of products, so compositions or apparatus or gadgets of any kind. Processes for manufacture are included as well, or processes for use. For example, you might have a product that's a lubricant. You can protect the lubricant itself and the composition that makes up the lubricant, but you can also protect the method of making the lubricant, and you can protect the method of using it. Sometimes computer software is patentable in some circumstances. Business methods are not patentable. So there are different things that you can actually cover with a patent. It's not just a product. And as mentioned earlier, that there are some criteria that need to be met when applying for a patent. And as this is a registered right, it's controlled by applying for a patent through a IP office such as IP Australia, and they'll examine the application against particular criteria. Now, for a patent, the invention that's disclosed in the patent must be new, and new means that it's not in the public domain. So it's different from something that might have been published in a journal article, in another patent, or in a trade magazine, or any of those sorts of things. It's different from what's known in what's called the prior art, but that's just what's publicly known. But it also needs to be inventive, or have an inventive step, and what that is that it's not obvious over what's known before. So if you took a product that you really wanted to make one, but you don't want to copy exactly what they've done, and you made a minor change, such as changing or fixing two parts of it together with a nail rather than a screw, then that would be an obvious change, and that would not provide a sufficient amount of inventiveness to get over the criteria required for a patent. But if you are looking at things and or testing out somebody else's product, and you find something, you make some tweaks to it, and you find something that's very surprising that you didn't expect, so an unexpected effect, that can be indicative that the product that you've just been investigating could have an invention over what was known in the art. So you must meet those sorts of criteria to get a patent. Also, a patent is an agreement between the government and the patentee, and the government provides a 20-year monopoly in Australia and in most jurisdictions so you get 20 years where you can use your invention, or you have a monopoly over your invention, and you can prevent other people from using your invention for those 20 years, and the government gives you that monopoly, and in return, your patent specification must disclose the invention in sufficient detail that a person that works in this particular area of technology could perform the invention across the full scope that's described. So you actually have to provide a lot of detail. You can't keep little bits of it secret. You need to describe everything when you file your patent application. And the reason for that agreement and for the monopoly is so that other people can come along and look at your invention and try and find other ways to improve it, and that means that we get progress, and things are constantly improved. So that's the point of the patent system, is to provide progress. Patents also have territorial limitations. So as Janelle said, for trademarks and designs, it's the same for patents. So you might be a company that is based predominantly in Australia and is only interested in protecting their invention in Australia. But other companies might want to protect their inventions in a number of jurisdictions. And the jurisdictions that might be important to consider, since there are so many countries and you don't want to have to pay to file in every country, you might want to consider where are you going to sell your product or provide your service, and perhaps also where are you going to manufacture your product if you're not going to manufacture it in Australia. Other considerations might be, you know, I'm not going to be active in a particular country, but I know there is a competitor there or a potential licensee there. They might be important jurisdictions to have your patent protected in as well. Okay, next slide, please, Gemma. But having a monopoly is not the only thing that you can get from a patent. It can be a really valuable business asset if you have technology that you can protect. So the monopoly is something that creates a hurdle for competitors to get into the market. So it can be if you're going to be the person that exploits or uses the invention that you've got protected. It can be that you can have 20 years or up to 20 years in the market and nobody else would be in the market with you having exactly the same product. So it creates a hurdle for competitors to do exactly the same thing as you, and that gives you something unique that you have in the market. But you can have an invention that you develop and sell it to another company that might be able to exploit it better than you, and it might be very valuable to them and they'll pay you money to buy the patent from you. So you can sell it and get a one-off amount of money for it. Another option would be to license. So you might have a patent and you're going to use it in Australia, but you're not going to use it elsewhere. So you could license that product, say in Europe, and another company might use it there and pay you a regular payment for the privilege of being able to use the patent in another jurisdiction. Alternatively, it's got on the slide there including in segments. It might be that a patent includes a number of embodiments of one invention and you're really only going to use one of them, but there are a number of options that might be used, and you might decide that you're going to keep one to use for yourself, but you're happy to license other embodiments to other people. So you can get an income, a regular income through licensing from a patent as well. But some of the things that are really important to startups and small and medium-sized businesses can be attracting investments, business partners and collaborators. When you have a patent and it's well protected and you want to go further but you need more money, or you need somebody with some other expertise to help you to get along that commercialization pathway to get you into to get your product on the market, having a patent can actually be attractive to an investment company such as an angel investor or a venture capitalist. They might be interested in investing if they know that there's protection around the product that they're going to be investing in. And similarly for business partners, it provides an option where they can see that there is a potential to have exclusivity in the product, and that might be worthwhile investing their money. So a patent can have value and can be valued, and it adds value whether it's tangible value or intangible value to a company. And so they can be important assets. It can also be used as a marketing tool to let people know that you have something unique that nobody else can do. So, you know, there's more than one way to use a patent. It's not just to prevent people to use your invention or to allow you time in the market on your own. Okay, next slide, please, Gemma. Confidential information is also another kind of IP right that's a non-registerable right, and so it automatically accrues when you produce I guess information that's from your intellectual or creative output, and it's something that has value to your company but is not publicly known, and you want to keep it secret so that it adds value to your business while it's not known. It can include trade secrets. It can include know-how, which is sort of like perhaps if you have a method of making something, a manufacturing method, that that there might be tweaks that you do during the method that wouldn't necessarily be known to other people, and it makes the process more efficient. That might be a know-how kind of trade secret. It could be customer lists and supplier lists and those sorts of things as well. But it's something that's kept secret. And an important thing to understand is that you know, a person receiving confidential information has an obligation to protect it. So before you disclose any confidential information to a person, they need to understand that obligation and have a right to refuse it. Confidential information is often, therefore, governed by confidentiality agreements or non-disclosure agreements that a person will sign, a person or a company will sign prior to them being in receipt of any information that's confidential, so that they understand the obligation that they have to keep it confidential. The problem with confidential information is that once confidentiality is lost, it can never be recovered, because once it's in the public domain, it's publicly known and anybody has the right to use it. So you've lost any value in it. And while it's possible to sue for damages, this is a court action, and it's under a tort called breach of confidentiality, and there is quite a high bar to meet to actually get damages. And also, you know, if you have a trade secret that you are going to use in the future, you're using now, and you have some licenses or some people that are using those trade secrets and are paying you money for them, you can't possibly assess future potential damages or potential income that you may have got. So you will never get damages back for things in the future that were potentially able to be got through that confidential information. So it's actually really important to meet the criteria of what confidential information is, and to show that it's confidential and that you were protecting it. It's actually important to have a management process for your confidential information, and not just saying, oh, well, that was a secret. I've been using it for a long time. No one knew it, and you know, it's a trade secret of our company. Actually, having a management process can be important. So next slide, please, Gemma. Okay, so in a management process for trade secrets, things that you can do include or create an inventory where you keep note of what you consider to be your trade secrets. And so you have a document or a database that keeps a note of the trade secrets that you have, perhaps how they're used, perhaps who knows them, where they've been disclosed, and perhaps also you know, whether if they do get disclosed, when they're disclosed and why they are disclosed. Because as we talked earlier, patents require you to keep things secret for a start. So it might be you have a series of trade secrets around a particular invention that you actually plan, once your patent process is underway, that it will be disclosed. So there might be valid reasons for disclosing things, but you need to keep them secret for a while. And also you might want to keep an inventory, because if you are licensing and know-how or trade secrets in any way, and they do become public information, that might affect your licenses. So it's good to keep a record, and then you know what you have, who knows it, and that it's still secret or when it is published. You might want to implement some security measures and controls around a particular secret. And that might include training of employees to make sure that they understand what a trade secret is, and also what their obligations are in keeping it a trade secret. And that, in fact, a trade secret, when they've when they've signed a confidentiality agreement, that might go beyond their employment. So once they leave, it's still a secret, and they're not they're under an obligation to keep it secret once they leave their employment also. One means that's a means of keeping something a secret is that if you have a process for making something and it has a number of steps, perhaps if there are secrets related to different steps, then perhaps only a few employees know something about each step. So separate employees know things about each step, and only a select few, perhaps the CEO and high people in the company, actually know all of the steps. So then individual employees don't know everything, they only know a part that they might be involved in. Okay, next slide, Gemma. So now I'm going to talk a little bit about IP life cycles and being in how you might use different types of registered IP or how other companies use them. In this particular slide, you can see that there's a company that has two products, product A and product B, and they have different sales cycles. And for example, product A may have gone into development, and at year 0, once they've got their idea sorted out, they've filed a patent application, decided on a trademark, perhaps the look of it is unique, so they've filed a design as well, and that product has gone on the market. And then perhaps through customer feedback, another product, some work was done on that product A, and some improvements were made, and product B was developed. And product B may still fall within the standard patent that was filed initially to cover product A, and it may be that it has the same look and the same trademark that it's going to be sold under, so the rights that are presently there stand. But it might be that something in the improvement is unique and changes the look of it. So a new design, a new standard patent, and a new trademark might be filed for those, and they might be filed at, say, year 7 prior to the product B actually going onto the market. And as you can see there, then you would have another 20 years, say from year 7 through to year 27, that would protect product B and not product A. And you can see also that once product B gets going, it's obviously much better than product A, so the product A sales drop right off. And then you might want to consider whether you want to keep that first standard patent that covered product A on, or whether you might abandon it for the last 6 or 7 years of its life because it's no longer fitting within your business plan. So from this, you have to understand that an IP strategy is flexible and fluid, and you need to keep thinking about what are your new things that are coming up, and how do I want to protect those, and how does that fit into our business strategy, and what money are we going to make out of those products. And also looking at the IP that you already have and making sure regularly that it is still useful and that you want to maintain that patent until it expires. Next slide, please, Gemma. Okay, this is an example. I'm sure everybody that's listening knows about Tesla cars, and we've got a guy here called John Smith who wants to buy a new Tesla. So what have Tesla got that that makes a difference to their products, and what sort of IP is involved? Certainly the Tesla brand is a very well-known brand, and it has a reputation associated with it for a high-quality product. And part of that high quality product is because they've invested a lot in their technologies, and they have a lot of unique technologies in their cars. So their trademark is very important because it identifies that product and identifies it as a Tesla brand product. And you know that it's come from the Tesla company. Also, you know, there might be different models of cars, so there might be a bunch of sub-brands that cover each model, so they might have a number of trademarks around their products. They also might have registered designs in the shape of the car or part of the car, for example, the wheel rims or, you know, the light fittings, those sorts of things. They might have a registered design around the whole car or parts of the car. And The shape of each model might change, so they might have registered designs around each model that they put out as well. The technologies that are used in the and how the car works are also protected by patents, and those patents might be filed by Tesla, or they might be filed by other companies, and Tesla might have bought the technologies from another company, or they might license them in so that they can use their technologies in the products that they are making. It could also be that some of the technology that they've developed over the time that they've been making their car and the development of that car, they might have had collaborations with other companies, and those collaborations will be governed by agreements, and those agreements will include ownership agreements. So it might be, there are a number of ways that you might organise a ownership agreement. For example, both parties may have equal ownership of any IP that comes out of it, and they might use it however they want to. It might be that Tesla pays the other company so that they can have complete ownership and the other company can't use it at all. Or they might have an agreement that over time Tesla will keep paying the other company a licensing fee, and they have exclusive rights or an exclusive license to use that technology over time. Tesla will also have used trade secrets in the way they manufacture their car or design their car, and they may have copyright in things like the design pictures and also the software that might be used in any onboard computers. So there's a lot of IP associated with one product in this sort of area. Okay, next slide, please, Gemma. But does the IP actually influence the product that John's going to buy? Why will he buy a Tesla instead of a competing brand? Well, I guess the thing is, looking at it, is the patents provide some unique things that are going to be only used by Tesla because they're the only ones that can use that kind of technology. And the Tesla brand, having the uniqueness and also having the reputation of the quality that they have, and the reputation in their brand, means that John may be well influenced by that. And it also might be that some of the unique things about the car provide John with the things that he is really looking for when he's wanting to buy a car. So all of those sorts of things do influence the decision in buying a particular product or a particular brand. So I guess it's important to understand that IP can be used in a broad amount of IP. Lots of different types can be used in one company, in one kind of product, and it's an asset, and it can have a lot of value to do with it, and it should be treated as an asset, and it has a life cycle, and it needs to be managed, that life cycle, so that continual development is being protected and continual IP is being generated. Okay, next slide, please, Gemma. So this is just a summary of that, and that IP is a business asset. It provides recognition, it can provide uniqueness, it can provide reputation and in relation to quality. It's legally enforceable, and it provides leverage in licensing and obtaining funding and maintaining collaborations and other sorts of negotiations as well. And there's a little note there about freedom to operate, and Janelle's going to talk about that very shortly. But one question to think about is, you're spending a lot of money on IP, so you know, are you actually going to recover those costs? And IP is valuable when you're actually making money out of it. So next slide, please, Gemma. Okay, this is nothing to do with clean tech technology, but just a little slide that tells you about or allows you to consider, provides an example of considering whether a piece of IP that you might have developed is worthwhile patenting, for example. This is a two-handed method of cutting hair and is a subject of a granted patent application to a person I'm going to call Mr. Yeh. So thinking about this is a method of cutting hair using two hands. So thinking about that, will Mr. Yeh make enough money back to pay for the patent and then make a profit? when he's cutting hair. So does he have a business that he can have lots of people doing this that will make all the money back, or is it just him? Who else wants to use the IP? This is IP for hairdressers. So are hairdressers actually a group of people or an industry that regularly license IP, that really consider this something that they would pay for a license to actually use this IP? So is there actually the ability to generate further income through licensing or selling this product? And another really important thing to think about here is, can Mr. Ye enforce his IP? Is he going to know when someone's infringing it? How would he know? And I guess the thing here is that a client having a haircut, when they leave the salon, nobody knows how that haircut was produced. So have they, so nobody's going to know whether their haircut infringed, or the person cutting their hair infringed the patent. So Mr. Ye would actually have to be in a hairdresser's and see somebody do it, or see an advertisement that somebody was was offering the service. So his ability to know when someone is infringing the patent and therefore enforcing his rights so that he does have the exclusivity is quite low. So in that respect, this might have been a very expensive patent for Mr. Ye to have obtained, and he might not actually have made money out of it. And then he might really have considered, would a better strategy have been to have a really good marketing campaign around this so that lots of people wanted to come to his hairdressing salon and he got a reputation in doing this kind of haircut, and that, he just was the first and the one that's known for it, and that might have been a better strategy rather than having a patent. So not all IP that's developed is valuable to a company, and you do need to see how it fits in your business strategy and that you will actually make money from it. So next slide, please, Gemma, and I'm passing back to Janelle.
Great, thank you, Kathryn. So I'll turn now to what the potential IP risks are for an organisation. And a lot of these points really just summarise what Kathryn has discussed already. So one potential failure is the failure to recognise IP opportunities. So once the cat is out of the bag, it might be too late for you to apply for your protection. So that's particularly notable for patent protection, where you need to apply for protection before there's any disclosure of your invention in a non-confidential way. I think there's also a need to understand the different types of IP rights and to plan what IP rights you're going to make use of in the business and manage those rights. There's also the potential for loss of IP ownership rights. So one thing to keep in mind is that if you're embarking on a collaboration with another party, it's important to be clear about the IP ownership and what intentions are. So turning to patented inventions, ownership of patented technology originates with the people who invent. So if you work on a collaboration with a party and it's people from the other collaborator who come up with a particular new invention, if you haven't agreed what the ownership will be of the rights, anything arising out of that collaboration, then the initial consequence is that it's the other party who is going to own those rights. So loss of IP ownership rights is something to be aware of. The third point I'll talk on about in a moment's time on another slide, but certainly want to be alive to potential infringement of third-party IP. And finally, this is an area that might be of interest. If you're embarking in a new area, rather than reinventing the wheel, there is also the opportunity to explore what has already been described and solutions to particular problems that have been applied for in patent applications. Not all patent applications go through to grant. If there is technology that has been described, published in patent applications but never taken through to conclusion, then you can make use of that information and that technology and perhaps build on it as a platform for some new ideas and improvements, and apply for and obtain protection for those improved versions. So next slide, please, Gemma. So this slide allows me to discuss a little infringement risk. So when launching a new product or service, one thing you need to keep in mind is not just what IP protection you might be seeking, but the fact that there are other people out there who may have already obtained protection. So we've already talked about a little patents, trademarks and designs. There is the potential for a new product or service to infringe third-party rights in those areas. So what do you do about it, and how can you plan for those actions? Well, one thing is to maintain awareness of what other people are doing in the world, and that will give you a clue as to the potential names of the owners of IP rights in those areas, and you can do some searching to see what type of IP rights those parties might have. It's also possible to conduct searching for patents, trademarks or designs that might block your ability to launch your new product or service. One thing to keep in mind is that IP rights are country specific, so your searches and clearance to enable you to launch your new product or service will need to be country specific. If it's the case that you're looking at launching in a number of countries, you might decide to conduct some patent or trademark or design clearance searching in just a couple of countries that are lead countries for you. And of course, the USA is often a target country for many companies around the world. People will often file for protection in their home country, and the next country that they look to for protection often is the USA. So seeking clearance early on in the USA will probably draw out major potential risks. So as to when you conduct these searches, a staged approach is probably worth considering. So while you're developing a new product or service, and if a business is in its infancy, expending great sums on clearance searching to check for avoidance of infringement is probably a bit too premature. It may be that it's worthwhile conducting these searches a little bit further along the process, but prior to launch of a new product or service. It's a bit of a catch-22 situation in some ways. Ideally, if you do all of the clearance searching at the outset, then you will be able to see what products and what IP protection there is that might prevent you from launching products or services in a particular area. But you don't have the returns coming in from your own IP to be able to fund those searches. Whereas at the other end of the spectrum, if you wait until too late and you're just about to launch a product or service, there might be a great deal of investment you've expended into developing your products and services, and to find out at the 11th hour that there's something blocking you could be, of course, a major problem. So somewhere between those 2 points in time, perhaps it's worthwhile looking at a staged approach to checking on these things along the way. Next slide, please. So before we wrap up our discussion, this slide introduces and recommends that you have in place procedures to capture and exploit the value created by your innovations. So for trademarks, it's worthwhile having a brand model. So for instance, are you the type of company that is going to rely on its key house brand, such as Steinway Pianos, focuses on their Steinway brand, or a branded house, perhaps in another example, Ford motor cars have both the Ford house brand together with particular models that are well known and protected by trademarks. With patents and designs, procedures to consider are, searching early, avoiding infringement of third-party rights, having internal procedures for disclosure, capture of information, and having a series of stages and gates for ongoing evaluation. And it's also worthwhile having a review of your portfolio periodically and checking in with your attorney. Copyright. It's worthwhile having robust agreements in place with third-party suppliers, ensuring you have assignment of any materials that are produced for you as a fee for service, and keeping a register of your copyright materials. And finally, with confidential information, Kathryn talked before about the sorts of things you can do to maintain your confidential information. Next slide, please, Gemma. So to sum up today, I hope that we've provided you with a bit more information to recognise that IP is a key business asset. It captures value and you want to make sure that you're obtaining value from your IP. Be aware of your IP. Is it protectable? Has it been protected? When should you protect? Where should you protect? Be aware of the options for protection, and then also be aware of IP protected by third parties and ensure that there is no risk of infringement. Finally, third-party IP information and publications can give you useful information, and you can use that as a resource for the further development of your business. So next slide, please, Gemma. Well, thank you everyone for listening. We have a little time available for some questions. So over to you, Gemma.
Thank you, Janelle. It does look like we're right on time here. If you do have any questions, we have Janelle and Kathryn's contact details up there, and they will be more than happy to have a discussion with you on anything discussed in this webinar today. And I'm just going to hand it back to Richard, who will sign us off. Thank you.
Thanks, Gemma. Yes, and thanks for keeping us on track. So on behalf of all the VCC members and other listeners today, I'd like to thank Janelle and Kathryn for sharing their knowledge on IP with us. I think it was a great overview. I'm sure if anyone needs to investigate their IP matters more formally, you can contact Kathryn and Janelle directly. As mentioned earlier, we're planning to have a second webinar later in the year, which might look at a theoretical company and how it develops a strategy for its IP. Your questions and feedback will help drive the content of that webinar, so I encourage you to make comment when it's appropriate for you to do so. The recorded version of this webinar will be made available soon, and I'm sure we'll be able to get a note out to all the registered participants of when that is available. So thank you everyone for listening as well, and this concludes our presentation for today.